It's not every day that a defendant charged with murder can have an active duty police officer come in as their own witness to say that they are peaceful and well liked. Let's bring in our guest to talk about the direct examination of this defense witness. We have national trial attorney Michael Jaafar here. Michael, it seems like the theme of the defense is that there's a lot of riffraff in this convenience store. He's had a lot of problems. And is that, you think, going to weigh greater for this jury than that video of a pretty aggressive defendant?
I'm baffled. I'm really baffled, Julia. Just like you said, I don't think I've ever seen a case where more than one law enforcement officer, more than one today, by the way, came in there as basically character witnesses. It's crazy. This is the one that's the detective on the stand is one of them, but the one before him also was the same one. It's really baffling to me. It absolutely is going to bode so well for the defendant, right? We all make our judgments on these cases. I always say cases like standing on a swaying boat left and right. If you ask anybody at any given point in time, where is the boat shifting? They'll tell you it's shifting left, shifting right. If you would have asked me during the prosecution's case, I would have said this is cleaving against Zarka. Now, with two police officers basically testifying for the man's character, for lack of a better word, absolutely the jury are going to absolutely soak that in. I think it helps him tremendously. I'm really baffled. Be honest with you, Julia, I don't even know what to say. It's a dream for a defense attorney to have somebody in a uniform come into the trial and say, hey, he's a peaceful person. He helps us with investigations. He's somebody who's very helpful. And there's a bunch of crime that happens in his store and he has to deal with it. So
we will see how it plays out, and we will see what Zarka says when he takes the stand. We know during the colloquy, he told the judge, I want to testify. That wraps up that witness, a strong one for the defense. Let's bring in national trial attorney Michael Jaafar, who is standing by. Michael Jaafar, there's an outstanding issue here where the defense wants to bring in the victim's past charge of larceny in another case. So some kind of proof that perhaps he was shoplifting in another location or had this similar crime that they are accusing the victim, the deceased victim of. Do you think that that should be allowed in by a judge? It's something that I think is still being argued between these parties, and the judge is weighing whether that information can come in. But we don't know if Zarka knew about that past.
If Zarka, and this is what the argument between the attorneys and the judge is going to be, did Zarka know about it? Because all that matters is whether or not Zarka went too far with his conduct, right? We know he came to the situation carrying a knife. He's going to testify that he felt he was threatened for his life. But if he did not know about the prior larceny, it's not relevant. It's not going to come in. If he did know about it, it is relevant. I've been involved in cases, one case in particular, where my client was aware of a criminal history, a violent criminal history of the victim in that case. That was relevant, right? That's a typical situation. If he had a speeding ticket or a DUI or a larceny or whatever the case may be, and he did it, even if he murdered somebody, and Zarka was not aware of it, then his conduct in that instant was not rational, was not reasonable, and he cannot bring in the fact, because all it's going to do is color the jury's mind. Well, he's a thief. He stole before, so he stole here. Because that's the conclusion that the jury's going to make. I'm very emphatic on this. If Zarka was not aware of the criminal history of Mark Garrity, it's not relevant. It should not come in. Period. End of story. Because if it is, if the judge does let it in, sets a bad precedent, Julia, because then you can bring in the criminal history of any victim, even if nobody who's committed involved in the crime was aware of. It would just be basically a free-for-all. I don't think it should come in if he didn't know about it.
Let me add this fact for you. The defense says, well, this would explain why he, the victim, tried to get away. Didn't want police to be called to this incident over, allegedly, the Gatorade. Does that change your analysis at all if it's about how the victim may have reacted in that minute? Because we do have the video of how these two were going back and forth. It seemed like the victim did not want to hand over his backpack. The defendant is not letting him leave. He is wanting whatever's in that backpack. So do you think that added part where the defense says, hey, it shows you how this victim was acting and why he would have been acting in a certain way because of this prior charge?
Based on the scales of the things that matter. I think it's not enough for them to bring it in, because at the end of the day, if the judge does bring it in, it opens up a free-for-all for, in future cases. I don't think that the fact that he stole before shows that he likely stole here, or that maybe this is why he came in with a backpack, because we're talking about a very specific thing, and the video is very graphic, and he came with a knife and then he stabbed him. So I just don't think that that would be enough, because it would be too prejudicial for the jury, way too prejudicial. If it wasn't if the jury was robots, I think that the judge would let it in. But the jury are human beings. They're going to tend to the inflammatory. They're going to gravitate to the inflammatory. I think it would be too inflammatory, based on the fact that, because stealing is a crime of moral turpitude, right? It's different. It's different than a DUI. It's different than speeding ticket. It's different than hitting somebody. It's a crime of moral turpitude. On immigration forms, they ask you, have you been convicted of a misdemeanor of moral turpitude? If you are, you're not admitted into the country. As a society, we've deemed stealing to be different, inflammatory. It goes to your character, right? I think it would be too inflammatory.
We will see, and certainly figure out what the judge is going to decide on that particular part of this case. Michael Jaafar, stand by, because we are a good friend of the defendant testifying on his behalf. Let's bring back in National Trial Attorney Michael Jaafar. Michael, from a legal standpoint, I am always surprised when I hear character witnesses, because we know the rules of evidence don't let you just go into everything. You can't talk about when they gave you a cookie in grade school or that you keep your house clean. You can talk about peacefulness and whether or not you're nonviolent, but it also opens the door for the state. If they can find anything in your history, they can bring it in terms of violence, so we don't see this often.
Yeah, this has been a love fest today, Julia. I mean, everybody loves this guy. This is going to really play well with the jury, right? The jury have now heard 3 witnesses in a row, 2 of them wearing a badge, saying very nice things about the defendant, right? I love the defendant now by basically, never met this guy. I want to give him a hug. It's got to play well with the jury. You saw the prosecutor there stop him there and even have his objection sustained, because it just went too far, and it's still not done yet. But yeah, this is absolutely beneficial to the defendant. Again, the ship is swaying left and right. If the jury was asked to vote today, right, I think they'd vote to acquit today. If they were asked to vote on day 1 or 2 of the trial, I think they would have voted to convict, right? So we'll see how this plays out, but so far it's going really good for Taiseer Zarka.
That's why we let it all play out. Evidence is not closed, and the judge reminds these jurors, don't make an opinion of this case until you've heard all of the evidence. Michael, stand by. More from the killing in a convenience store trial for Taiseer Zarka in North Carolina after this. Bring back in Michael Jaafar, attorney standing by with us. So the prosecution didn't have much to counter this witness, Michael, with. They didn't bring up any police reports of some issues of violence, any text messages, nothing to show that this defendant does have this reputation of violence or anything in his background that would counter what he said about his peacefulness.
Julia, you have stumped me twice on this show. I thought that was going to be the 3rd time I got opened up, because you said he might have opened up the door. I'm like, I should have thought of that. And then the way the prosecutor started talking, I thought, you know what? She was right for a 3rd time. He probably opened up the door, and then I had a breath of relief when he just ended. 20 seconds later, he was just making a basic statement, because that witness, I mean, let's just admit it, he looks like Santa Claus, and the way he testified in favor of Taiseer Zarka was very helpful. I thought maybe he opened up the door, but clearly he did it. So I think that this ended up being a very good day for the defense. Yeah, that was a little bit contentious, very short. I guess he has nothing. I guess the prosecutor had nothing to do to basically counter the points that was made by that defendant, by that witness. This is really good for the defendant. Yep.
Yeah, I agree with you. It's clear they have nothing to impeach or come back with. But let's talk about this jury view, because that has been the big conversation today. The defense wants these jurors to be inside of that convenience store, seeing how everything is laid out, I presume, and they want it to happen before the defendant testifies. So can you first just talk about the jury view? What do you think it could help with the facts that we have in this case, outside of all those pictures that we have? This
is extremely important. Julia, I've never been at this store. I have to assume that the defense believe that the jury doing a jury view will help them, because maybe the area is a rough area. Maybe the entrance to the store has a bunch of hidden corridors and blind spots for Taz, right? So maybe what they're going to be able to say is, look, Taz works every day on the bottom left side of the building in his office. He has his cameras here. The cameras have these following blind spots. So for all he knew, so he came with a knife. Him coming to the interaction with a knife was reasonable. He didn't come with a gun. He came with a knife because it's very, very conceivable that the victim would have had at least a knife, maybe a gun. So there was a blind spot here and a blind spot there. And so this is why him coming to the interaction was reasonable. And then it escalated from there when Mark Garrity kicked him in the leg and yada, yada, yada. So the jury view, Julia, in my opinion, is it's so crucial. And it's important that it happened before Taz testified, because Taz is going to be testifying a bunch of things that the jury won't know if they don't have a jury view. So I think it's very important, and the timing is important.
So the jury has not obviously heard from Taz himself yet, but they did hear a police interview with him speaking to police after this incident. Let's take a moment to look back at that.
Okay, yeah. No, yes, I can bounce back. But the minute he reaches his back pocket, okay, I'm not taking no chances with anybody. That's it. I said, you pushed it, you're going to kill nobody, you're going to stab nobody, give me that bag, took the bag from me, put it on the floor, okay, took a swing at his chest, okay, I'm tired of hitting me in the head, look at the video, okay, and I pulled him the old-fashioned southern style, and put him on the floor, knocked him down, okay, and he took his hand, whatever, he's running outside when we took the bag from him. And I told my employee, everything feels like a dream, it's like Sabbath. It's just a couple of seconds between, please, in the name of Jesus, man, just put the bread on the floor and go between hit and hit and everything just happens second, and I'm not taking no chances with anybody.
At this point, he's told the judge he's going to testify, but he hasn't told the jury. Based on what we've seen, do you think he could change his mind, or should he still go forward with testifying?
I saw both police interviews. I thought he lied in both of the police interviews. I think he's going to have to clean that up. He has to testify, but when he testifies, he will be impeached with what he said in those interviews. So he's going to have a lot of explaining to do. He said this seemed like a dream. Maybe that will be his saving grace.
Coming up soon. Thanks so much, Michael Jaafar, for all of your analysis. We are going